All right, this is Palmer versus Bowers. Each side will have 15 minutes to present their arguments, and you may reserve up to 5 minutes. Thank you for bearing with the court. You heard obviously what happened. So we had some kind of emergency here in the building, and we all had to evacuate for probably a good 45 minutes or so by the time we all got back up here and everything.
The way this case has gone, it doesn't surprise me. That would be something that would occur.
At least we didn't hear the case.
Absolutely.
All right, so you may proceed.
Thank you, Your Honor. May it please the court, I'm Tim Fitzgerald. I'm here on behalf of the appellant, Richard Palmer, who is the plaintiff in the case below. I would like to reserve 3 minutes.
That's fine. Thank you.
For rebuttal. There's really one issue before the court this morning, and it relates to the trial court's vacating of an agreed injunction order that was entered in the early stages of this case back in 2012. Let me go back and perhaps give some factual background to the court, because I think that would assist in understanding what this case was about and why the injunction order was entered. This case arises out of a dispute involving a company called Hall Contracting Services, which was a company that for years had been involved in the installation, maintenance, disassembly of printing presses for the newspaper industry, which with the advent of technology, the printed newspaper and that industry is somewhat depressed. Began in about 2008 that Hall Contracting started to have some financial difficulties. Before that, Hall Contracting was a very viable and successful company. It was a closely held company involving only a handful of shareholders. And unfortunately, in 2012, 3 of the shareholders decided that they wanted to arrange a way for them to convey shares in Hall Contracting amongst themselves and modify what was a majority shareholder agreement that had the shareholders had entered into that controlled their interests. Several of the provisions in that agreement are issued in this case, one of which was that it prohibited the sale of or ownership of shares in Hall Contracting by a competitor. One of the individuals in this case, Robert Bowers, was an individual who owned another company out in, I believe it was in Colorado, that was also involved in the printing press business. So he was a competitor of Hall Contracting, albeit he was also a shareholder. There was also a provision in that majority shareholder agreement that required that before any shareholders could offer their shares to a third party, they had to first offer it to the company and to the other shareholders. It was a right of first refusal that the company and shareholders could exercise, and it needed to be exercised before the shares could be transferred. Recognizing that those 2 provisions prohibited Mr. Bowers from acquiring more of an interest in Hall Contracting, Mr. Bowers got together with another shareholder, an individual by the name of Graham Hall, and another individual by the name of Robert McKenzie. And in the spring of 2012, they decided that they were going to enter into what's been described and referred to in this case as a 3-step transaction that would allow them to circumvent the majority shareholder agreement and its restrictions on the transfer of shares. And what they did was, behind the scenes, without advising any of the other shareholders, including Mr. Palmer, was that they decided that Mr. Hall, Graham Hall, would acquire Robert Bowers' shares. At the point in time when this all took place, the interest that they each had was that Graham Hall owned 31.5% of Hall Contracting, and Bowers also owned 31.5% of Hall Contracting. Individually, they could not change the majority shareholder agreement because it required a 2/3 majority vote. So the first step of the transaction was that Graham Hall acquired Robert Bowers' shares in June of 2012. Actually, it was consummated in July of 2012, which brought Graham Hall's ownership interest to 63%. Again, not sufficient to be a 2/3 majority to change the majority shareholder agreement. So that's where Robert McKenzie got involved. Robert McKenzie owned, I believe he owned 17% of Hall Contracting. And the second step of the transaction was that Graham Hall acquired Mackenzie's shares. So at that point in time, Mr. Graham Hall owned more than 2/3 of the shares in Hall Contracting. At that point in time, they amended the majority shareholder agreement, and they deleted out the restriction that prohibited ownership by a competitor, and they eliminated the right of first offer to the corporation to acquire the shares. At that point in time, Graham Hall sold back to Robert Bowers, actually it was to his wife, Judith Bowers, all of the shares in Hall Contracting, such that at that point in time, Judith Bowers owned 73.5% of the company. And it was at that point in time that Robert Bowers proclaimed himself to be the president of the company. In September of 2012, he stepped in, he removed Mr. Palmer from his positions at the company. He forbade Mr. Palmer from being in any way on the property. And from that point forward, he has proceeded to, in essence, dismantle Hall Contracting. As soon as Mr. Palmer was removed from the company, that's when this complaint was filed, and a motion for TRO was filed because there was a shareholder meeting that had been scheduled to take place in November of 2012, where Mr. Bowers planned to get approval to sell off most, if not all, of the equipment at Hall Contracting. There was an auction that was scheduled in the latter part of November 2012. There was a hearing that was conducted where the parties entered into an agreed injunction. It wasn't a TRO, it was an injunction. The motion was for a TRO because it sought temporary relief to prohibit that shareholders meeting from taking place, and it prohibited the auction from taking place. But it was ultimately agreed that it would be an injunction that would allow the auction, Mr. Palmer allowed the auction to take place, and in exchange for that, it was agreed that Mr. and Mrs. Bowers would not be, during the duration of the lawsuit, would not be permitted to vote their shares or conduct any shareholder meetings while the litigation was pending. That's the injunction order that we are here on appealing today. Excuse me, the vacating of that order is what's before the court. Subsequently, the case proceeded, and there was an interlocutory summary judgment order that the court entered, which has not yet been reviewed on appeal because it's interlocutory. But based on that summary judgment ruling, the trial court vacated the injunction order in August of last year. There's two reasons why the vacating of that injunction order was improper. First off was that the trial court did not have jurisdiction to vacate that injunction order. The injunction that was entered in November of 2012 was itself, as an injunction, it was a provisional remedy, and it was immediately appealable at that point in time. No appeal was taken from that case. And so once the 30 days ran for an appeal from the injunction order in November of 2012, that became a final order that could not be vacated or reversed absent certain circumstances. And those circumstances...
You indicate it can't be vacated, but can't any injunction be subject to dissolution? Injunctions are dissolved all the time.
If there is compliance with 60B.
Why would it have to be compliant with 60B for a dissolution of an injunction? I'm not sure I understand that.
Because the injunction itself is a final order, and the court does not have the inherent authority to vacate a final order. So if 60B can be complied with, which is the only way that a final order, short of an appeal, can be vacated or modified, that's the only way that it can be done. And in this case, there was no proper 60B motion that was filed in the case. It was the motion that was filed in June of 2014 was captured the motion to vacate, but it was a 1.5-page motion. It made no effort to comply with 60B. In itself was an untimely motion.
I know you had, I know there's, other things pending, cross claims, whatever's pending at the same time. You still have stuff pending in the
There is,
trial court?
yes.
Okay. Let's say that all that had been resolved and you lost the case. Okay. You're not contesting that at that point the injunction would dissolve.
I guess at that point,
Because you said the injunction is only during the pendency of
Right.
the case.
by its own terms,
Right.
it would have dissolved at that
That's what I'm saying.
And the appeal then would be as to the merits of the underlying case, which is still a viable pending, appeal.
Right,
It will be
I
filed once those other
understand
claims are resolved.
I'm just trying to figure out the nature of all this as to how it works in regard to the injunction when the case is not over yet, and.
Well, one of the other claims that was resolved on some.
Oh, sure, I
was
understand.
was for a permanent injunction. And so that would be one of the other ways that the preliminary injunction would have been resolved, would have been either by way of the entry of a permanent injunction or it would dissolve of its own terms, which is what the provisions of the order say. It will be pending during the litigation. So there's, again, the court lacked jurisdiction to vacate its own order, a final order, short of a properly supported 60B motion. And that motion was never filed. And the trial court does not have the authority on its own to sua sponte vacate an order. None of the briefing that took place in the trial court was a proper 60B motion. The reference to 60B didn't appear until a reply brief that the court allowed the defendants to file.
You said did or did not?
The judge did allow a reply brief to be filed, which was the first time that any reference to 60B was even made. But again, in order to be entitled to 60B, there are three things that have to happen. You have to be entitled to it under one of the provisions of 60B, 60B 1 through 5. There has to be a meritorious claim or defense that is available, and the motion itself has to be timely. It's our contention here that the motion, even the one that was not referencing 60B, was untimely because it was filed 19 months after the injunction order itself. And
Outside of the issue of timeliness of the filing, after the reply brief was filed and the request for reply, there was an evidentiary hearing, correct?
Not an evidentiary hearing, just an oral argument.
There was an oral argument. And what was the context of that argument? Was it a 60B motion argument? I'm assuming that the oral argument's in the record?
It is.
The
Yes,
transcript?
there is a transcript in the record. And yes, there was argument as to whether or not there was a proper 60B motion that was filed. And so the argument that's being made here on appeal is the exact same argument that was made in the trial court below, which was that there was no proper 60B motion that would have allowed the trial court to vacate the order.
Counsel, you are into your rebuttal time now. Do you want to save that? or-
Yes, unless there's more
Thank you.
questions, I'll
Yeah,
reserve
we were
the-
asking questions, so. All right, thank you.
Good morning, Your Honors.
Good morning.
Your Honors, my name is Bonnie Finley, and I represent the Appalese Hall Contracting Services, which we sometimes refer to as HCS in the briefs, and Robert and Judith Bowers. Before I get into a couple of things I wanted to say here today, wanted to answer a couple of the questions that you asked to the appellant's counsel. And I think you were right on. I think you guys really understood what the nature of the problem was. You said courts dissolve injunctions all the time. Why couldn't that be the case right here? And I think this is not addressed by appellant in his briefings, but it is addressed by the appellees in their briefings, where the courts of Ohio do have inherent authority to dissolve injunctive orders with or without a motion from any party. And in fact, It can be TROs, it can be preliminary injunctions, and so I don't think the difference matters, but even courts have the authority to dissolve permanent injunctions. And so whether or not there was even any type of motion filed, I think the court possessed the authority to dissolve the injunction. But let me go through also, and not necessarily the facts of the case, because I think that Tim did a very good job of doing that with a couple of small exceptions that don't really matter all that much with respect to how much each party owned. But with respect to when the filings occurred, the temporary restraining order that was granted in November of 2012 was an agreed order. The parties came together and agreed upon an order signed by the judge, sanctioned by the judge, and it was called a temporary restraining order. Whether we want to call it a preliminary injunction or a temporary restraining order, it doesn't really matter. So that was in November of 2012. Within the next year and a half, discovery took place, and in the summer of 2014, Graham Hall was granted summary judgment as to all of his claims. At that point in time, HCS and the Bowers had not filed for summary judgment, but he was granted summary judgment as to all the claims asserted against him by plaintiffs. Based on that decision by the court, by the lower court, 1.5 months later, actually it was about 40 days later, the appellants, or the appellees, filed a motion to vacate the temporary restraining order, the agreed TRO that was entered into in November of 2012. So that was about 40 days, 1.5 months, let's say. The reason, and it was a one-page filing, or it was actually 2 pages, and it basically said, listen, based on your summary judgment order, court, there's no issue here, because what the court determined was that what Hall did, and really then that indicated what Bowers did with respect to the transfer of shares, he said was valid. It was, the corporate documents permitted him to do so. So based on that also then, the court, we filed the motion to vacate. They briefed that, everybody briefs it, and another of the questions was, did everybody have an opportunity, not necessarily to present evidence, but all arguments you could possibly put forth on this issue? And yes, that happened in December of 2014. In the meantime, in the spring of 2015, the Bowers and HCS filed their own motion for summary judgment. And this is important on what they filed for. They filed for all claims that were asserted against them by the plaintiffs, and they also filed on their own counterclaim. The judge took a little bit of time and decided in the summer of 2015 that yes, these remaining defendants, because Hall is basically out of the case at this point, the Bowers and HCS are entitled to summary judgment on every single one of the plaintiff's causes of action. They aren't entitled to summary judgment on their own cause of action, the counterclaim, but every single cause of action that the plaintiff had asserted against them, they're entitled to summary judgment. 1 week later, the judge, apparently during that week, took a look at the TRO that was granted in November of 2012, based partially on the fact that the plaintiff even had some claims and therefore was entitled, by agreement of the parties sanctioned by the court or otherwise, to get a TRO. And he dissolved that TRO. He vacated that TRO at that time.
But that TRO was agreed amongst all of the parties, correct? That was an agreed order?
I'm not sure Hall agreed to it. I do know that at the time, Judith Bowers, who is one of my clients, she agreed to it. And I mean, for all intents and purposes, all of the appellees did agree to it. I'm not sure Hall did though.
Okay, and this is maybe a little bit off track, but the order vacating the TRO says that if any party believes it's still necessary under the current conditions, then you can file for a new TRO.
Right, and that's, I'm sorry.
However, having read the briefs submitted on this issue, the court notes that irreparable harm would appear to be difficult to demonstrate as monetary damages are available. And there would be a sufficient remedy. So it would be difficult. It might be difficult. The court is acknowledging it might be difficult to get a new TRO now. which is not the same thing as everyone agreed to it and made it order of the court, and it no longer has any validity in this ongoing litigation, is it?
I read that to say that's one of the reasons why you can't have the TRO anymore, because the circumstances have changed dramatically. If I were the judge at that point, I would have written that you can't prove your case at all, and not even with the Rule 65 heightened standard, because you have no claims left.
But might Palmer have claims related to what Hall's claims used to be back at the beginning of this case?
I'm sorry, could you say that again?
Yeah, I understand the difficulty, but, I mean, we have multiple parties here, and what was initiated as a shareholder derivative action, correct?
Correct.
And it's Palmer that's standing here that's saying you cannot get rid of that TRO. It's not Hall standing here saying
Oh,
that.
no.
Sure, I understand that. But part of what I'm guesstimating the initial allegations were is, you know, other things people have agreed to are happening that are harming the corporation and harming my interest in the corporation, correct?
It's effectively.
And so we all come to some sort of agreement that during the pendency of this litigation, something is not going to happen.
Right, let's hold off, let's status quo.
Okay, so it, just bringing me back to this order, where it says you can file a new TRO, I don't see that there is irreparable harm if you do, means that you have lost something.
It implies to me, when I first read that, because it didn't make sense to me, and I wasn't involved back then, but I said to myself, oh, okay, there's obviously some claims still pending here. Some of Palmer's claims still pending, because he's talking about irreparable harm. And it turns out, and Tim will correct me if I'm wrong, it's my understanding that all of Palmer's claims, his initial claims and his complaint, are gone. The only ones that remain are the counterclaims by us. I believe Paul might have a counterclaim too. And maybe on rebuttal you can ask them that question. And so that's why I was a little bit surprised why, and now that I actually thought about it, I thought maybe the judge was saying, gosh, if you want to file an amended complaint, maybe in these 2.5 years, you do have other claims that have materialized, and maybe they're not based on the shareholder agreements or the amendments to the shareholder agreements, because that was the crux of the entire case before. Maybe you have some additional claims that you want to file, maybe file an amended complaint, maybe, I'll let that come in, and then you can file a TRO. That's how I read it in light of the circumstances that Palmer had no claims left. I could be wrong with that. But then going back to, I looked at the clock beforehand, and I think the appellant's argument hinges on whether hinges upon whether the November TRO, the November 2012 TRO, was indeed a final order. I believe it was nothing of the sort. And even if it were a final order, these 2.5 years later, after summary judgment is granted, if in fact 60B was the right mechanism to dismantle this TRO, all of the requirements were met. And the two attacks that appellant has is timeliness, and then the second attack is that they weren't adequately heard. And your questions dealt with the second one. Weren't you adequately heard at the hearing? And furthermore, perhaps appellant can tell us what additional arguments does he think would have swayed the judge at that point. But as far as timeliness and whether or not 60B was the right mechanism with which to move for this motion to vacate, it was moved under the sub 4 and sub 5 parts that do not require it to be within a specific amount of time, but it has to still be within a reasonable amount of time. And I think in the briefings you'll see that, because the motion to vacate was filed approximately 40 days or a month and a half or so after the summary judgment was rendered. Those were the changed circumstances upon which the motion to vacate was filed. And I believe those are that would be timely.
Did you argue below that the motion to vacate alternatively was filed under common law? Was there any discussion, did we talk about common law?
And it's
Court's inherent.
That's actually a really good question. And I'll get my dates a little bit more clear here. It was the summary judgment was granted in favor of Hall in May of 2014. In June of 2014, filed this. It really was a 2-page order, but basically said, listen, based on the, and it didn't cite any rules. It didn't cite.
It's just over.
It just
Then
said,
it's over.
right, this is no longer valid anymore based on your ruling, Your Honor. And then there was a change in counsel. And this is when, and it was funny, it wasn't even my firm at that point, but it was another firm at that point. But that counsel withdraws, and then in September and I think in September or October of 2014, counsel was substituted. That counsel then, who is now with our firm and wasn't at the time, asked if he could supplement. Can I file a reply brief in support of this motion? Because in his mind, 60B applied, and it hadn't been argued. And subsequently, we've looked at it and felt that, gosh, we don't think 60B applies. But it was about a 13-page brief, and whether or not it was 60B or not, he really developed the arguments about why the temporary restraining order should be vacated at that point.
Was the appellant given the opportunity to file a certified?
You know, I believe that he moved forward. I believe that attached to his motion, he filed, what he did was file a motion to strike the reply brief. And I think he sought leave to file a reply. I believe his proposed reply was attached thereto. Not sure about that actually, but regardless, that 2 months later or so, when they had the hearing, it was December 30th of 2014, the judge was able to hear all of the reasons why, and even so whether it was in writing or not, I believe he was able to hear all of the reasons why the appellants now thought that the restraining order should remain in effect. But what I think also is important is there was a 6-month period of time from the end of December to let me get the date exactly right, to July 27th. The court didn't do anything with respect to the motion to vacate. And then that was on July 27th is when the judge granted summary judgment in favor of HCS and the Bowers. And then exactly 1 week later, on August 4th, 2005, the court granted the motion to vacate. And so partially I believe that, A, if it wasn't a final order, the court had inherent authority to dissolve it, whether or not any of the litigants even said a peep about it. But from the judge's order, you can see that he did take into consideration all of the arguments of counsel, he even says so, and that he made his decision. Importantly also, the judge didn't cite 60B, perhaps because the judge was wiser than we were in arguing 60B, and he was saying to himself, this isn't a final order, of course, but I like your reasoning, or I have my own reasoning, and I'm going to grant this motion. So regardless of final order or which rule was relied upon, whether it was inherent authority or 60B, the judge did make the right decision, partially because there are no claims remaining on behalf of Palmer, and the injunction was granted in agreed order, but it was granted in favor of Palmer. So I would ask that, unless this court has any further questions, I would ask that the judgment of the lower court is affirmed, and I thank you all for your time.
Thank you.
I think to really understand where the disconnect is with what the trial court judge did here is the vacating of the TRO or injunction. And there is a difference between TRO and an injunction. TRO has a limited duration, it's 14 days, and it dissolves on its own terms. It can be extended another 14 days. But otherwise, it's a preliminary injunction. So this was a preliminary injunction. I know the order that was handwritten by the parties, probably a jury room, refers to a TRO, but it was an injunction. But what the judge says in his order vacating is that the circumstances have changed dramatically in the case. And I recognize that what he referring to as the summary judgment rulings. And what's odd about those summary judgment rulings is that he makes, and this is why we think the summary judgment is an error, is he analyzes the changes that were made to the majority shareholder agreement as if it was nothing more than a breach of contract case. And that's not what this case is about. This is a case involving breach of fiduciary duties between shareholders. And whether or not the majority shareholder agreement was complied with in literally, it isn't what controls here. The parties that were involved in modifying that shareholder agreement owed fiduciary duties and were prohibited from making those changes without telling the other shareholders they were going to do that. And that seems to have been completely lost on the judge. But the fact of the matter is that the way the trial court seems to have interpreted that decision is that the Bowers legitimately are the legal owners of the shares that they bought from Graham Hall. And the problem is that the Bowers never paid for those shares. And Graham Hall still has a claim in the case for the $150,000 that Bowers was supposed to pay him. So that the changed circumstances that seem to suggest that Bowers now is the legitimate owner of these shares in Hall Contracting is flawed. He's not. And that's the reason why the judge didn't grant Graham Hall's motion for summary judgment, where Graham Hall says, if you deem this transaction to be legitimate, and Bowers is the legal owner of the shares that I sold to him, he's obligated to pay me $150,000, which no one disputes. That's what the terms were. And the judge said, no, you're not entitled, Graham Hall, you're not entitled to summary judgment on $150,000 because there's still a question of whether or not Bowers owns those shares, because there is a statute in Ohio that says that until the price is paid for the shares that are bought, the seller always has the right to rescind that sale.
Okay,
And so
Counsel, your time.
Okay, so with that, I would ask that the court reverse and vacate the order, vacating the injunction in this case. Appreciate your time.
Thank you so much, and the court will take the matter under advisement and issue a written opinion that will be sent to both sides as well as released on our website electronically. And thanks again